If you've been subjected to extreme cruelty or battery in the United States by a U.S. citizen or lawful permanent resident spouse, then listen up, because you are not dependent on them necessarily for your immigration status in the United States. You may be eligible to petition for your own residency. There are various qualifications which I will not thoroughly discuss in this video, but I will discuss the 4 qualifying relationships under which you could file for your own residency. The first one would be if the abusive spouse is just that. They're your spouse. It's a lawful permanent resident or a U.S. citizen abusive spouse, then you may be eligible to petition for yourself. Secondly, if you are divorced from this individual and it's within 2 years, so if you're divorced and a U.S. citizen or lawful permanent resident partner and it's within a 2-year window from that divorce, then you can file for yourself within that 2-year window. If that spouse has passed away, you also have a 2-year window to do a self-petition, but in that situation, that deceased spouse would have to have been a U.S. citizen, not a lawful permanent resident. Thirdly, if the spouse lost their citizenship or their residency because of something related to the domestic violence and related to the abuse, then you could also base your self-petition off of that kind of relationship. However, you'd have to do that within 2 years of them losing either their residency or their citizenship, U.S. citizenship. And then finally, if you were never actually legally married because of your abusive partner's bigamy, then you could also, I don't think that's particularly common, but you could also potentially qualify for VAWA self-petition. My name is Liechty. I'm an immigration lawyer, and I love helping couples and families get together in the United States, or in this situation, helping individuals navigate how to maintain their status when the relationship that brought them here is difficult. Thank you. Bye.